Good afternoon, everyone, and welcome back to our weekly webinar series on IBC and other matters. Today's topic is of special importance. I think we have seen very less discussion or very few such sessions on NCLT Rules 2016. Although for advocates who are in practice in NCLT, the reference to these rules must be regular. But I think it's important for us to understand what is in the rules and understand IBC's implementation better. Over to Anil, sir.
Thank you, Ankit. So we thought of this subject, which is NCLT Rules 2016, when the structure of NCLT was formulated by central government, and all the cases from Company Law Board was transferred to NCLT, and some of the cases from High Court, or probably most of the cases from High Courts, were also transferred to NCLT benches. Now, these NCLT rules, in fact, these were made much before the IBC was promulgated. However, these rules are applicable on the proceedings in NCLT. So there are some supplemented rules, because see, when we see the IBC, the application for insolvency under section 7, 9, 10, these are separate rules. Then there are liquidation rules, and then there are PPIRP rules. These are all supplemented rules. However, the NCLT Rules 2016 continues to be applicable on the proceedings, the constitution of bench, powers of bench, proceedings. So this is something which every lawyer, or rather every client, or rather every litigant must understand. What are the limitations of a lawyer? What are the limitations of an NCLT member? What process has to be followed? And these processes are well defined. When you would see, when we collectively read this NCLT Rules 2016 rule by rule, and with some judicial pronouncements under IBC, it would be really very interesting to know that everything is applicable in all the proceedings, and whatever bench is doing, whatever our lawyer is doing, it's all within the rules and within the powers of the members of tribunal. So when we talk about the NCLT rules, it is the like National Company Law Tribunal. So under the company's law, this is considered as tribunal, whereas under the IBC, NCLT is considered as adjudicating authority. So it is only the reference, the name is different, adjudicating authority or tribunal. Under the company's law, it is called tribunal. Under the IBC, it is called adjudicating authority. But NCLT Rules 2016 are applicable rule by rule, clause by clause. So this subject may be a little longer. It may be completed to my understanding, it might be completed in 3 parts. So this is certainly very important for those people who would like to understand the process, who would like to practice before NCLT, and even for insolvency professionals who would like to understand why our lawyer or why the bench is doing this or that. So starting with the important definitions under this NCLT Rules 2016, some of the definitions are very, very regular. Act means Companies Act. Whenever there is a reference of Act in the rules, it means the Companies Act. Address for service. Now, address for service is something which is again a matter of controversy. The shall means the address furnished by a party or his authorized representative, at which service of summons, notices, or other processes may be effected under these rules. Now, if as an applicant, I have to provide the address of the respondents or address of the other parties. Now, if I have a wrong address, the notice would be served on that wrong address. However, that would not be considered as a correct service of notice, because the address for service should be correct. If the address is not correct, then to my understanding, the service is not correct. Now, therefore, it is even provided in the rules that even the mobile number, email ID should be mentioned in the address for service. Now, application, when I say application, means any application, and application also includes interlocutory application or proceedings filed under the provisions of the Act, including any transferred application or transferred petition. So this is application, and then we will also read the definition of interlocutory application. Authorized representative is something which is very important for all of us to understand, means a person authorized in writing by a person to present his case before the tribunal as representative of such party as provided under section 432 of the Act. So when we go to 432 of the Act, let us see section 432 of the Companies Act, what it says. A party to any proceeding or appeal before the tribunal or the appellate tribunal, as the case may either appear in person, like the appellant can appear in person also, or authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioners or any other person to present his case before the tribunal or appellate tribunal, as the case may be. Now, besides the chartered accountant, besides the cost accountant, company secretary, advocates, even any other person is also authorized to represent a case. Now, any other person, and he may be an employee of the company, he may not be an employee of the company, but in case any other person is authorized, that should be accepted by the tribunal, even if that person is not a chartered accountant, company secretary, cost accountant, or a lawyer. This is what is the understanding which actually makes from this section 432 of the Companies Act. Now, bench has been defined under section 419 of the Companies Act, bench of a tribunal. This includes circuit benches constituted by the president with prior approval of the central government to sit at such other geographical locations as may be necessary, having regard to the requirement. So we have seen in the income tax, there used to be circuit benches or camp offices of the tribunal. So these are circuit benches, and this was basically to facilitate the applicant and the respondents to avoid traveling, and the bench will go and hear the cases closer to their location. Now, the benches of tribunal has been defined under section 419 of the Companies Act. So what it says that there shall be constituted such number of benches of the tribunal as may be by notification be specified by the central government. As you understand that presently, I believe there are 28 or 26 benches which are notified by the central government for NCLT. The principal bench of the tribunal shall be at New Delhi, which shall be presided over by the president of the tribunal. The powers of the tribunal shall be exercisable by benches consisting of 2 members, one of whom shall be a judicial member and the other shall be a technical member. Now, there is a proviso that provided that it shall be competent for the members of the tribunal authorized in this behalf to function as a bench consisting of a single judicial member and exercise the powers of the tribunal in respect of such cases or class of cases or such matters pertaining to such class of, as the president may by general or specific order specify. So there is a possibility of single member benches, but the single member benches should only be judicial members, and that too in case it has been constituted. So it is not possible that if technical member is not present, then the judicial member can take a decision on that day. That is not legally possible. However, in case the president allows the single member bench to function and enjoy all the powers of a bench, then only the single member bench can function and the single member bench can pass orders. However, in the absence of any technical member, the judicial member would not be able to pass an order unless the single member bench has been specifically constituted. Now, the definition of the benches of tribunal further continues as per section 419 of the Companies Act, which further says provided further that if at any stage of hearing of any such case or matter, it appears to the member that the case or matter is of such a nature that it ought to be heard by a bench consisting of two members, the case or matter may be transferred by the president, or as the case may be referred to him for transfer to such bench as the president may deem fit. So president has the power to shift any cases, transfer any case to any other bench or to the bench of president. The central government by notification established such number of benches of the tribunal as it may consider fit necessary to exercise the jurisdiction, powers and authority of the adjudicating authority conferred on such tribunal by or under Part 2 of the IBC. Now, if the members of a bench differ in opinion, if the members of a bench differ in opinion on any point or points, it shall be decided according to the majority. Now, in case there are 3-member bench, then in case 2 members are having same opinion, that would be delivered. But in case the view is divided equally, then the decision would not be taken, and in that case, the case will be referred to the president for hearing on such points or points which are having conflicting views. So in that case, the president may refer these points, not the entire case, but these points to any other bench, or when the other members are trying to decide this, then the decision would be taken by the new members and the old members, and a majority of that. Now, for example, the old members are 2 and there is a conflicting view, and then the 2 new members are appointed, so the total are 4. So even in the 4, if the 3, including the old members, if the 3 agrees to a particular view, that would be delivered. That can be delivered and that would be binding. However, in case, again, within the 4 members, if the view is divided, then again it will go to the president, and the president will further refer it to a different bench. Now, this central registry means the registry in which all applications and petitions or documents are received by the registrar for allocation to the concerned bench of the tribunal for disposal. So one is the central registry and the other is the registry. Central registry, where all applications are received and finally allocated, whereas the registry is that there is a registry attached to each bench. So each bench has a registry, and the entire NCLT has one central registry. Central registry is where all the applications are received. So whenever we file an application, it goes to central registry. The number that we get, that number pertains to the central registry number. In case we find, I believe the number starts from, they reset the numbers, because if the number is prefixed or I think followed by a year. So in case there is a number means 20/2022, that means this is the 20th application that has been received by central registry during the year 2022. So that is the total number of applications that are received in central registry, which is further allocated to different benches for disposal. Now there is a word called certified. So whenever there is a word written certified, that the certified document should be submitted, there are meanings to certified. So the first meaning is certified as provided in Section 76 of the Indian Evidence Act 1872. Now the Indian Evidence Act 1872 says what is the meaning of certified copies of public documents. It is provided in Section 76 of the Indian Evidence Act 1872. Now Section 76 says every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fee Therefore, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be. And such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever the such officer is authorized by law to make use of a seal. So what is the provision? That suppose any public officer who has a custody of public document. So then the next thing comes is, what is a public document? Now, for example, like any order issued by the tribunal or adjudicating authority is a public document. Any person who has a right to inspect can apply for a copy of also. So then the copy can be obtained and together with the certificate written at the foot. So whenever there is a such copy given, it should be certified true copy, stamped as a certified true copy, and it should be signed by the official with his name and his official title, like maybe sub-registrar or registrar. So these are the kind of see, like whatever we do, whatever we see every day, it is basically governed by some rule, and such copies so certified called certified copies. So these are something which is called certified copies. So there is an explanation attached to it. Any officer who by ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of such documents within the meaning of this section. Certified further continues. So this was the part A of the definition of certified. This was the part A. I will just see this part A says certified as provided in section 76 of the Indian Evidence Act, and the clause B of the same section where the definition of certified is given is certified as clause B says certified as provided in section 6 of the Information Technology Act 2000. Now, Information Technology Act under section 6 says use of electronic records and electronic signatures in government and other agencies. Now, it further says that this was the heading. It says where any law provides for the filing of any form, application, or any other document with any office, authority, body, or agency owned or controlled by the appropriate government in a particular manner. B. The issue or grant of any license, permit, sanction, or approval by whatever name called in a particular manner. The receipt or payment of money in a particular manner, then notwithstanding anything contained in any law for the time being in force, such requirement shall be deemed to have been satisfied if such filing, issue, grant, receipt, or payment as the case may be is effected by means of such electronic form as may be prescribed by the appropriate government. So this was the section 1 of the section 6 of Information Technology Act. Section 2 says the appropriate government may, for the purposes of subsection 1, by rule prescribe the manner and format in which such electronic record shall be filed, created, or issued, the manner or method of payment of any fee or charges for filing, creation, or issue any electronic record under clause A. So this particular section says that use of the certified as provided in section 6 of the Information Technology Act. So section 6 of the Technology Act says that any document which is filed like in a digital form, and that will be considered as filed, and any copy taken from that portal would be considered as certified. Then certified copy issued by the registrar by the registrar of companies under the Act. So the registrar of company also issues certified copies. So that will be considered as certified copy, because there are many documents which are filed to MCA portal, and at times these copies are required to be certified. So it is certified by the registrar of companies if required. The clause D says the copy of document as may be downloaded from any portal, any online portal prescribed under section 398 of the Act, or a photocopy of the original pertaining to any company registered with the Office of Registrar of Companies of the concerned state, duly certified by a legal practitioner or a chartered accountant or a cost accountant or a company secretary. Now, in case we download any document, from any online portal prescribed under section 398 of the Act. Now, 398 of the Act, when we talk about 398 of, when we talk about 398, so we have this 398. So this section 398 of Companies Act 2013, which was effected from 1st April 2014, this talks about the provisions relating to filing of applications, documents, inspection, etc. in electronic form. Now, this particular section 398 prescribes that the as you might say, notwithstanding anything to the contrary contained in the Act, without prejudice to the provisions contained in Section 6 of the Information Technology Act, the central government may make rules so as to require such from such date as may be prescribed in the rule, that such application, such notices, application, balance sheet, prospectus, returns, register. So all this can be filed electronically. So these are the relevant rules which actually which is provided in section 398. So it says that if we download any of the documents from Registrar of Companies portal, from MCA portal, and all those documents are supposed to be filed electronically under section 398 of the Act, then when we download a copy and then it is certified by a legal practitioner or a chartered accountant or a cost accountant or a company secretary, that is also considered certified. So I believe,
so
yes,
we're looking at MCA 21. I think we're looking
yeah,
at online portal 398 section is empowering the government to set up the online portal, that is MCA 21, and any document that you download from that website would come into under this meaning. Also, I think it also extends beyond the section. It says that any document pertaining to the company which is maintained under the Companies Act, it can also be certified by the chartered accountant. So in case you talk about a share certificate, you talk about many other documents that are maintained under Companies Act by a company for compliances and otherwise, they will all come under that.
yes, I believe, Ankit, yes, but then there are two situations. One is this certified. The word certified is also, as per the definition, this is what we read as certified. Now, when we let us try to reiterate what is certified. Certifies, for the first is as per the Indian Evidence Act. The second is as the second is, again, we can even think about because see, this is something which is every day we have to use it. Certified document, we always say. One is this 76, section 76 of the Indian Evidence Act, and the second is the definition part is the as certified as provided in section 6 of the Information Technology Act. The third is the certified copies issued by registrar of companies, and fourth is copy of documents as may be downloaded from online portal. So I think the clause D is used the most, or a photocopy of the original pertaining to any company registered with the officer. So I think you are right. The first part says the copy of document as may be downloaded from any online portal prescribed under section 398 of the Act, or a photocopy of the original pertaining to any company registered with the Office of Registrar of Companies of the concerned state, duly certified. So the two things that you said, that yes, it is. So any document, if it is certified by a legal practitioner or certified by a chartered accountant, cost accountant, or a company secretary, so this is what is all about certified. So now we go to the certified by tribunal. So when we talk about certified, that is the documents submitted as an evidence should be certified in one or the other manner. Second is certified by tribunal, means in relation to a copy of a document certified to be true, copy issued by the registry or of a bench of the tribunal under its hand and seal as provided in section 76 of the Indian Evidence Act. So in case we have to take an order which is certified by tribunal, that is something which is defined here. When we submit documents, that is something which is defined in subclause 9, which is defining certified. Fee is very simple. Any fee which is payable for they see, like, let us understand what kind of fees are payable. The for filing petition, application, interlocutory applications or documents, or for certified copies. So fee for filing, fee for taking certified copy of the document or order of the tribunal or such other paper as may be specified in schedule of fee to these rules, and include any modification as may be made thereto, or any fee as prescribed for filing of documents to the tribunal by these rules. So the fees can be for filing, fee can be for taking certified copies, and the fee can be for yes, I think these are the two things that the fee can be deposited. Interlocutory application, and the I think the main difference between this main application and then the interlocutory application means an application in any appeal or original petition on proceeding already instituted in the tribunal but not being the proceedings for execution of the order or direction of tribunal. So this is not the main application. This is not the main appeal. This is not the original petition, but this is an application filed within a matter which is already pending before the bench. That is called IA. In short, we always call it IA. So these are the different interlocutory applications. We'll see in further slides what exactly can be the IA. Party is also defined, means the person who prefers an appeal or application or petition before the tribunal, and includes a respondent or any person interested in the said appeal, application or petition, including the registrar of companies or the regional directors or the central government or the state government or the official liquidator or the RBI. So these are all the parties. So the one word party defines all, like applicant, respondent, and the other government authorities. Petition means a petition or an application or an appeal or a complaint in pursuance of which any proceeding is commenced before the tribunal. Persons interested means a shareholder, creditor, employee, transferee company, and any other company concerned in relation to the term or contest referred to in the relevant provisions of the Act, or any person aggrieved by any order or action of any company or its directors. Because in various income tax or various Companies Act clauses, or even in IBC, we have seen that the appeals have been filed by those persons who are not even party to this litigation. In my case, Technology Development Board versus Anil Goyal, when NCLT passed an order, saying that there is no separate categories of first charge holder or second charge holder. So the first appeal was filed by Kotak Mahindra Bank, who was not even party to in this case. And however, they filed this application as person interested. And the person interested can be any person aggrieved by any order or action of any company or its directors. Now, every time that we go to the court or we hear the word pleadings is used very often. What exactly is proceedings? Pleadings means and include application, including interlocutory application, petition, appeal, revision, reply, rejoinder, statement, counterclaim, additional statement, supplementing the original application and reply statement under these rules and as may be permitted by the tribunal. Because see, every time we go and see, then we normally say that the pleadings are completed. So when we say pleadings are completed, that means everyone uh, who has to file a reply or rejoinder or any statement or any additional statement that has been completed as permitted by the tribunal. So in some cases it is the right, like in some cases the even the reply has to be filed, and uh, the bench, the tribunal may take a decision that the reply is required or not, and the tribunal may even decide a matter before even reply is filed, because as may be permitted by the uh, tribunal. Registrar means the registrar of the tribunal includes such other officers of the tribunal or bench to whom powers of the registrar is delegated. Registry and central registry. We have seen these two, central registry and registry. Registry means registry to the of the tribunal or any of its benches as may be, which keeps records of the applications and documents relating to. So the registry keeps the records, central registry receives the applications and then allocate. Secured creditor is having in whose favor a security interest is created. The definition of security interest is the same as provided in the IBC. There is no difference, word by word it's same. I'm not sure why it is provided, because it was, these rules were made in Companies Act. Now is the transferred application or transferred petition. So this is also defined, means any proceedings which has been transferred to the tribunal from company law board or the high court or the district court or BIFR. So this is, all these are provided in the section 434 of the Act. Now, what exactly 434 of the Act says? Because the definition of transferred application says, as provided in clause A, C, and D of subsection 1 of section 434. Now, let's go and see section 434 of the Companies Act. And it says all matters, proceedings, or cases pending before the board, means company law board, constituted under subsection of 10 capital E of Companies Act, immediately before such date shall stand transferred to tribunal, and the tribunal shall dispose of such matters, proceedings, or cases in accordance with the provisions of this Act. B. Any person aggrieved by any decision or order of the company law board made before such date may file an appeal to High Court within 60 days from the date of communication of the decision or order of the company law board to him on any question of law arising out of such order, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing an appeal within such, allow it to be filed within a further period not exceeding 60 days. So B was not automatically transferred. A was automatically transferred. First is the A. This 434A was automatically transferred. So all cases under the company law board or the High Court, or so this was all under the company law board. All cases from company law board was transferred. B was not transferred because this is something that the appeal was supposed to be filed before High Court. So appeal was still fileable. Now the C was also transferred. So as we can see again, A, C, and D. Let us see what C is. All proceedings under the Companies Act, including proceedings relating to arbitration, compromise, arrangements, and reconstruction and winding up of the companies, pending immediately before such date before any district court or high court, shall stand transferred to the tribunal, and the tribunal may proceed to deal with such proceedings from stage before their transfer. So all these cases will also be transferred to NCLT. That was notified on 1st of December 2016. Provided that only such proceedings relating to the winding of the company shall be transferred to the tribunal that are at a stage as may be prescribed by the central government. Provided further that only such proceedings relating to cases other than winding up, for which orders for allowing or otherwise of the proceedings are not reserved by the High Court, shall be transferred. So in case the orders are reserved for order, will not be transferred. In case of winding up, the stage is very important. At what stage the winding up was going on, That is very important, and the central government will prescribe at what stage the application would, the winding up will be transferred to the NCLT. Provided further that all proceedings under the Companies Act 1956, other than cases relating to finding of the companies that are reserved for others for allowing or otherwise such proceedings, other than cases of finding of where the orders are reserved. So one scenario which is very important, this is this proviso. Provided further that any party, I think I need the attention, Ankit, if you would just try to understand. Provided further that any party or parties to any proceedings regarding to the winding up of the company pending before any court, immediately before the commencement of the bank in IBC Ordinance 2018 may file an application for transfer of such proceedings, and the court may by order transfer such proceedings to the tribunal, and the proceedings so transferred shall be dealt with by the tribunal as an application for initiating CIRP under IBC. So this particular proviso in fact talks about like any application can be moved to High Court where any winding up proceedings are continuing, and that application any party can submit and say that this application now be shifted to NCLT so that we will consider this as a CIRP. So this is also a very important, because we have seen many applications have been transferred, many such proceedings have been transferred from High Court to NCLT, and that has been considered as the fresh initiation of CIRP. So the proceedings relating to winding up of the company which have not been transferred from High Court shall be dealt. In case a particular proceeding have not been transferred, that will continue with High Court, and that will continue under the Companies Act 1956. Sorry. Provided also that proceedings relating to cases of voluntary winding up of the company where notice of resolution by advertisement has been given under subsection 1 of section 485 of the Companies Act 1956, but the company has not been dissolved before 1st April 2017, shall continue to be dealt with in accordance with the provisions of Companies Act 1956 and court rules. The central government may make rules consistent with the provisions of this act to ensure timely transfer of all matters, proceedings, or cases pending before the Company Law Board or courts to the tribunal under this section. So this is, Ankit, very important that we actually have to see like all these cases which are before the High Court, those can be transferred. All cases of winding up can be transferred to NCLT. Any questions so far, Ankit?
Yeah, so there is a question from Anand Churaji. He has a question on clause C, which you were discussing earlier, because I think you're talking about different clauses. He's saying he has a query on
Yes.
clause C. So here, like when we say that all proceedings under Companies Act 1956, including proceedings relating to arbitration, compromise arrangements, and reconstruction and winding up of companies pending immediately before such date, may proceed to deal with such proceedings from the stage before their transfer. So basically, they will be transferred to the tribunal. That is the idea. I think should be clear. He's saying, what is the difference between? There is a question that what is the difference between petition and application, not related to the C, but otherwise.
There is no difference.
Yeah, there's no difference
there is
between
no difference.
petition and
These are all
application.
the names which can be taken as per you sweet will. Anyone can say it's an application. Anyone can say it's a petition. However, appeal is different. When we talk about appeal, it means that there is an order against which the appeal has been filed.
So then Mr. Kabir was asking that section 432, can an insolvency professional represent? I don't think that's permitted, although an insolvency professional may be a chartered accountant or a company secretary or a cost accountant. But then when you talk about the list of eligible authorized representatives for the
No,
for the company.
what I understand is any person authorized, by the applicant can represent. I mean,
I think it
irrespective,
has to be so if you look at 432 right to legal representation, um,
any other person to present his case before the tribunal or the appellate tribunal, as the case may be.
a
So
party to any proceedings appear in person or authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioner or any other person to present his case. So it's actually any person. So it can
yeah,
also be an insolvency
he
professional.
can also be an insolvency. So the only thing is that
Okay.
he cannot represent himself, but yes, himself he can definitely represent because he is a party. So he can
Hmm.
represent it because it is rare where the party can represent himself. Number one. Number two, the if he can uh, authorize one or more chartered accountants company, but any other person also can be authorized. So this is very clear that insolvency professional can also take the authorization from the applicant or uh, on whose behalf he is appearing. He can take the authorization and can appear. No doubt about
So Nishanji is asking that can an IP present represent in cases where he's acting as an IP? So I think there again we have
it. No,
we heard the we heard the NCLT bench at multiple forums where they these days are saying that the insolvency professional may represent himself and save legal cost also. But then I think the preference is that advocates present the IP as well.
no, my understanding is that legally there is no bar
Mm.
because the insolvency professional is a party. If he's a party, then he can. If he's not a party to any application, or he's not a respondent to, but party means applicant, respondent, or any interested party, then if he's not a party to the litigation, then he can take authorization. But if he's a party, then he can simply say that I'm on the memo of parties number so and so. So I'm representing this particular memo. So he can represent. There is no
Okay.
restriction that he cannot represent.
So we have a question from Vikasji. He says that please explain the negative statement in the definition of interlocutory application.
So there is no negative statement. There is no negative statement in the interlocutory.
It just went by maybe third slide or fourth slide.
Yeah. But not being a proceeding for execution of the order. No, execution of an order cannot be an interlocutory application. It has to be it has to be a fresh application. Execution of an order, it has to be because see, one particular application has been disposed of, and then the execution has not been done. That cannot be a IA. That has to be a fresh application or direction of tribunal. So, like direction of tribunal, but not being a proceeding for execution of the order or direction of tribunal, the direction of tribunal has to be a separate application. When I say that the tribunal, when my uh, application says that I need the tribunal to direct so and so, I feel that this direction of tribunal, because see, when I go to the definition of interlocutory, I will actually see I will actually take you to another definition of inter. Now, this rule 32 defines the interlocutory applications. Every interlocutory application for stay, direction, condonation of delay exemption from production of copy of order appealed against or extension of time paid for in pending matters shall be in prescribed form, and the requirements prescribed in that behalf shall be complied with by the applicant, besides filing an affidavit supporting the application. So when I see this, Rule 32 also talks about directions, whereas the definition part, when the sub rule 15 says not being a proceeding for execution of the order or direction of the tribunal. So this direction of the tribunal is kind of conflicting. When we see this rule 32, it says also for direction. When we see this sub rule 15, and it says not being the proceeding for execution of the order. So to my understanding, IA can be filed for any direction of tribunals if it is within the main application. So this is where we can conclude. However, the direction here is a negative part, and the direction there is a kind of positive part in Rule 32. So therefore, we will assume that the direction can be, for direction, we can file an IA. However, for execution of an order, the IA cannot be filed. Any other question, Ankit?
I think we can move on. There is one question on section 434, which talks about some that a matter is pending in NCLT on a matter of jurisdiction, and the person has filed. The same was also pending since 2015 in a district court. So I think where matters of jurisdiction, I think we can proceed forward. If I remember correctly, matters of jurisdiction can easily be taken up by the NCLT principal bench, and whatever decision is decreed then has to be either accepted or appealed against.
Still, I couldn't understand the question. In case you can see what
The
exactly
question is that there is some matter which is pending on question of jurisdiction. So there the jurisdiction can be ascertained by NCLT, and that's what I would say.
No, I think
so the matter is not being talked about by the person who's raised the question. He just said that it is pending for decision on question of jurisdiction. So what is the matter is would determine the jurisdiction.
Even if it is pending for determining the jurisdiction, and if it is a matter which is as we can see, A talks about company law board, and B talks about only the B is not even transferred. C talks about all proceedings under the Companies Act pending before any pending. When we talk about subclause C, it talks about any proceeding, district court or high court. I think whether the appropriate jurisdiction or not, it will be transferred to NCLT. And if it has not been transferred, then this application can be moved. Under this proviso, the application can be moved because it is written the proceedings any court, before any court. So it can be moved. Maybe it's a wrong jurisdiction, but application can be moved for transfer to NCLT. That's very clear. Now we go to Rule 3, which is computation of time. Whenever we talk about any time, as per any rule or as per any timeline provided in the Act, how the time would be computed. So the first rule is that the day from which the said period is to be reckoned shall be excluded. Now, in case I say that within 60 days, and if the bench is passing an order today, that within 60 days, that actually means that the day on which the order is being passed, that day has to be excluded. That day has to be excluded. This is the first rule. The second is, and if the last day expires on a day when the office of the tribunal is closed, that day shall be excluded. And that is for filing and all. If I have to submit a reply, I have to submit a rejoinder, I have to submit any other document. And in case on that particular day, in case the bench says that you have to do it in within 15 days, and the 15 days happens to be a Sunday, then of course that day also would be excluded. and any succeeding day on which the tribunal remains closed shall also be excluded. Any succeeding days. Now, suppose it's Sunday, after that it is Monday, maybe a public holiday. So then all it actually would be excluded. So the Tuesday would be the date when the document or the any compliances has to be done. Now is the section 11. Section 11 is Ankit, a much larger subject, and I believe we can take some questions, and we'll start the next episode on the coming Sunday from section 11, because section 11 followed by various judicial pronouncements, because on section 11 we have seen a lot of litigation. So we can take up some questions, or you can add something from your side, and in case there are questions, or if anyone has raised hand, we can even allow him to speak, and we can see
So
if
I
there
will
is any
read out.
question coming.
So I'll read out
Yeah,
a
you can
few
read out.
questions that have come in. So this is from, I'm not able to capture the name. In case of share transfer dispute, the applicant lives in Chennai, but the registered office of the respondent is Kolkata. If the application is filed in Chennai, will it be transferred to NCLT Kolkata?
No, that is not a rule of transfer, because see, when we talk about section 434, section 434 was like it was applicable from the day the IBC was promulgated, and also in another uh, ordinance. So when we talk about totally application filed in a wrong jurisdiction today, and then saying that it will be transferred to another bench, that is not something which is uh, like the bench has to decide whether it will be transferred, or bench has to decide, or it will be rejected for want of jurisdiction. Because when we will see, I have seen the complete rules. I have seen that whenever we file an application, there is a format. And in that format, it is very clear that the first certificate that a person is supposed to give, that the jurisdiction lies in this bench. So whenever an application is filed, whenever, that format has to be complied with. So if the format has not been complied with, so let us try to understand. So this is the format of NCLT 1 is the form in which all applications are supposed to be filed. And this is one of the requirement jurisdiction of the bench. The petitioner declares that the subject matter of the petition is within the jurisdiction. So this declaration is filed by the petitioner applicant. So in case of any mistake, the bench will have to decide whether to reject or to transfer. Yes, Ankit. Because this is to be given by the applicant. This is the duty of the applicant as per the rules. Because NCLT 1 form very clearly says that it is the duty of the petitioner to declare and also sign on that affidavit that he has verified. Yes, Ankit.
So similar questions that in case during the pendency of an application, if the registered office of a CD is shifted from one location to the other, what would happen to the jurisdiction?
I think this fact has to be brought to the knowledge of the adjudicating authority in case it is IBC, or the tribunal in case it is a Companies Act, and the tribunal will decide, like in case of change in the register office in between, then what happens to the pending applications. To my understanding, the application which is filed and partly heard can be disposed of within the same bench, even if there is a change in the register office. This is my understanding.
So then we have a question that what is the reply? What is the difference between reply and rejoinder?
No, the reply is the reply, and there is still a applicant, and then there is a respondent. Now, the applicant has filed a petition, and the reply has been filed by the and the reply has been filed by the respondent. And after the reply, then the applicant also may get an opportunity with the permission of the tribunal to file a rejoinder. So this is what is called, and then there is a possibility that on the rejoinder, the respondent also files the rejoinder. So this is a kind of pleadings, total pleadings. The rejoinder is that after filing the reply, after seeing the reply of the other person, whatever issues has been raised in the reply, the petitioner wants to file a rejoinder.
So sir rejoinder is also a document, also a process.
Yes, the rejoinder is also a document which is a part of the process.
No,
We
sir
actually have
rejoinder. There is something called sir rejoinder, SUR dash rejoinder. So I think this might be another process with respect to the reverting to the rejoinder itself.
No, I think I can even find out in the NCLT rules what you're saying. SUR.
SUR.
Sir, SUR rejoinder.
SUR dash rejoinder, but I think you can just look for SUR. So not sure if this is.
No, there is nothing like in the rules. There is nothing like SUR rejoinder.
So that's done. Then we have. So yeah, it's called sir rejoinder is actually somebody has said it's an additional rejoinder.
It's an additional rejoinder, so we can even sir rejoinder. Not really sure.
Must be a process wherein in special circumstances might be permitted by the court.
Yeah.
So can then we have a question that in case of merger, transferee and transfer company has different jurisdiction, then can final petition of second motion be filed differently or at one NCLT? So normally you would like determine the transferor and then take permission from both NCLTs. That's how we have seen this happening. Wherever there are proceedings or companies registered in multiple jurisdictions, then both NCLTs are normally involved in a merger process.
Yeah, I think you're right. But then we actually have to, again, we'll try to answer it in the next session, because we are also trying to go through the research, because this NCLT rules is a very, very large subject. So we would.
Then there's a question on dress code for RPs if they are presenting before the NCLT.
That also will come in the subsequent slides. We have it. We
Yes.
have covered in our subsequent slides. That will come in the next session.
So great. I think that's about it. There are many other questions, but I think the relevant questions I've already taken. And then I think let's resume next week and take this forward.
Yes, Ankit, this is a very, very important subject, and we are very happy to see the participants, number of participants very large. And every, like I understand that the way we are trying to explain the practical part of it, although, as I always say, that it's a collective learning, we are also learning along with all of you. And we are adding our practical experiences. And this is only, we can say that it's an endeavor that everyone should spend some time in learning. So therefore, we will continue this NCLT rules. We will try to shorten it, because otherwise the rules is very large. But yes, we will try to shorten it, and we'll try to pick up only the important parts. Otherwise, the rules goes into something like too detailed rules. But yes, it is important for any practitioner under the Companies Act or under IBC. It's very, very important. So I think we can conclude. Thank you very much, participants.
Thank you, everyone. Thank you.
Thanks a lot.